Why? Why did you do this? And I think sometimes understanding why we do certain things will help us not repeat it. If it's
asking the court to give Mr. Montoya that opportunity.
A courtroom on a Friday night, docket still running, and a judge who refuses to let a defendant hide behind a script. Tonight we're breaking down two back-to-back sentencing hearings that could not be more different, and both hinge on the same brutal question. Can you actually explain why you did what you did? Case 1. Nathan Tyler Montoya, 30 years old, no prior record, a steady job at Amazon, pleading no contest to a charge involving his own niece. His defense is asking for something huge: deferred adjudication, a legal path that could let him walk away without a permanent felony conviction on his record if he completes probation clean. That's the ask. But Judge Stephanie Boyd isn't interested in a rehearsed apology. She asks him one question, point blank: why did you do this? And what follows is one of the most uncomfortable, meandering non-answers you will hear in a courtroom this year. Depression? Self-loathing, even Montoya calling himself a victim. Stick around, because that answer is going to cost him. Case 2. George Lever Hawkins, a University of Houston graduate, an honorably discharged veteran, now homeless and battling methamphetamine addiction, charged with assaulting a peace officer. His attorney is fighting hard for treatment over prison, Veterans Court, Drug Court, a private treatment facility, but every door keeps getting a partial no. Two men, two very different arguments, one judge deciding how much mercy the system has left to give. Let's get into it.
R008168, State versus Nathan Tyler Montoya. Can I have parties announced for the record for the state? Defense.
David Andre Woodard.
Please, we're on the record.
David Andre Woodard for Mr. Montoya.
And are you Mr. Montoya?
Yes, Your Honor.
All right. You entered a plea to the lesser included offense of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for deferred adjudication. According to your plea bargaining agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state is opposed to your applications. This will run concurrent with County Court Cause number 734433. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the TAP evaluation and PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Any objections to the TAP evaluation or PSI, state?
Not Judge.
Defense?
No, Your Honor.
All right, state, you are opposed. Do you have any witnesses?
We do not, Your Honor. In lieu of the witness, we do have a letter from one of the witnesses, will enter it in as State's Exhibit A. I believe there's no objections.
No objections, Judge.
We'll reserve our argument.
All right, then the court will accept into evidence State's Exhibit A if both parties will give me a chance to review it. All right, if you'll give that to the court reporter.
Yes.
Thank you. And if you could, I think it's marked on the inside as State's Exhibit, correct?
It is.
All right, defense, do you have any witnesses?
No, Your Honor. Only argument.
All right, then the court will hear argument. State, you are opposed?
We are opposed, Your Honor, but we'll reserve.
All right, defense.
First off, Judge, looking at the PSI on page 2, this is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel. If you, Ron, if you all could just move to the other end. Hi, if you could just move to the other end, we're on the record. No problem. You're our counsel. All right, we're back on the record. And counsel, what page did you say?
I'm on page 2, Judge, of the PSI regarding Mr. Montoya's criminal history.
Yes.
The only criminal history that he has, Judge, is this current case and also the misdemeanor case that's going to run concurrently with this case. Aside from that, he has no prior criminal history. He's 30 years old. At the time of the incident, he was employed at Amazon. He was working. This case was resolved fairly quickly, Judge. Mr. Montoya accepted responsibility fairly quickly. He took a plea, and now we're here before the court. Since he's been in custody, I believe since May of 2024, he's had no contact with his brother, who drafted the letter. I think that was State's Exhibit number A, and he's also had no contact with. Speaking with him, he realizes what he did was not only wrong and inappropriate, but it was also a criminal offense. Also, there's a TAP evaluation that is the last page of the PSI report. And the TAP evaluation does not show that Mr. Montoya has any substance abuse issues or any alcohol related issues. We are asking the court to grant his application for deferred. I know it's a difficult case for courts to consider granting a person deferred adjudication. We're asking the court to give Mr. Montoya that opportunity, one, because he has been in custody. He's had time to reflect and to think about what he did, not only what he did, but the repercussions that happened with his niece. Looking at the PSI and also the letter that the state submitted, does look like the need through some mental health trauma. She likely would still continue to experience, but she has been doing well in school. There will be no other contact with Mr. Montoya and we're just asking the court to consider his application for deferred adjudication. If the court does not consider that application, I believe the plea bargain was for a cap of 7 years. We're asking the court to possibly consider a downward departure and placing him in TDC for a lower amount of sentence opposed to the 7 years.
All right. Is there anything you wish to say?
I do accept responsibility for my actions.
All right. Just 1 second. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? That's it.
Yes.
All right. You can lower your hand, state your name for the record.
Nathan Montoya.
All right. So is why? Why did you do this? And the reason why I asked that question, because that's a part of, I think, an introspection, right, to yourself. So why? And I think sometimes understanding why we do certain things will help us not repeat it if it should not be repeated. So why?
Why? I believe I do need more self-reflection to understand as to why it was something that should have never been have done. Going through my own depressive episodes and self-loathing, I would say I have caused myself to go down a spiral of deep creativity, I believe.
Mhm.
However, I am able to bounce back up and to truly self-actualize myself. As to why, or that it may be because I'm also myself the victim itself, and I understand that happens because of that kind of thing. I'm still trying to come to terms as to why, basically. I don't like saying I don't know yet.
Okay.
But it is something that I do regret. I have lost something precious to me. Understand?
All right.
If I can say.
That for a second, because it's genuinely jarring. The judge asked one simple, direct question, why did you do this? And gave Montoya every opportunity to answer honestly. Instead, we got depression, self-loathing, a claim of being a victim himself, and finally, after all that circling, I don't know yet. For a plea built entirely around the argument that he's accepted responsibility and reflected on his actions, that non-answer is a problem. Deferred adjudication isn't handed out for good behavior alone. Courts want to see genuine insight, real accountability, proof that this won't happen again. What we just heard instead was avoidance dressed up in therapy language. Notice too how he pivoted almost immediately to his own losses. I've lost something precious to me, rather than naming what the harm actually was or acknowledging what his niece went through. Would you have granted deferred adjudication after that answer? Or did that moment just cost him his freedom? Keep watching, because the judge's ruling is coming right up, and it does not go the way the defense hoped.
All right. Any questions from the state?
Not necessarily.
All right. Thank you. I appreciate your testimony. All right. This is what the court is going to do. The court is not going to grant your application. The court will find you guilty. This will run concurrent with County Court Cause Number 734433. There's to be Chapter 62 compliance. There's to be no contact with the complainant. There's a $1,500 fine, time and money run concurrent. Court will give you credit for any time served. I am unsure if the therapeutic community, if you will qualify for it. I'm going to request it for you because I think there are some mental health issues and some trauma going on with you based upon what has happened to you and based upon what I read in the PSI report that he has brothers who are in prison for the same thing. And one of the brothers was actually a perpetrator of him. And the court will sentence you to just 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not with regards to sentencing, Your Honor, we do have the gavel.
All right.
Not from the defense, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. With regards to the therapeutic community, you will still have to request that. It doesn't increase the time that you're in custody, but it can help you I would say, deal with your past trauma. You understand? I do appreciate that you accepted responsibility for this. Sometimes people never accept responsibility. Sometimes they blame other people for their.
Here's the legal breakdown you need to actually understand what just happened. Deferred adjudication in Texas means a judge holds off on entering a formal conviction while the defendant serves probation. Complete it successfully. And in many cases, the charge never becomes a final felony conviction on your record. That's why the defense fought so hard for it. Once the judge denies that application and instead finds you guilty, the case flips into a straight conviction with an actual prison sentence. Here, 7 years, matching the cap the defense and state had already agreed to in the plea bargain. Notice something important though. Even in denying leniency, the judge didn't ignore the trauma in Montoya's own background. The PSI apparently showed his brothers had prior related convictions, and one of them was actually his own abuser. That's the judge trying to hold two truths at once: accountability for the crime, and recognition that abuse cycles don't happen in a vacuum. It's a good example of how sentencing isn't just punishment. It's the court trying to weigh public safety, the victim's well-being, and the defendant's own history all at the same time. That's case 1, closed at 7 years. Now the docket moves straight into an entirely different kind of case.
2024 CR 5390, State of Texas versus George Laverne Hawkins. Could our parties announce for the state?
Andrew Harris, setting with the state.
Defense?
Renee Munoz.
And are you Mr. Hawkins?
Yes, ma'am.
You entered a plea on June 20th, 2024 to the offense of assault of a peace officer. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison. The state is silent on your application. They're taking in consideration 2023 CR 7315, 2024 CR 5389, County Court Cause Number 729000. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report? State?
No, Your Honor.
Defense?
No.
Have both parties had a chance to review the TAP evaluation? State?
Yes, Your Honor.
Any objections?
No, Your Honor.
Defense?
Yes, Judge, and no objections.
All right, the state is silent. Defense, do you have any witnesses?
No witnesses at this time, Judge, only a clarification, explanation / argument.
All right, you may proceed.
Thank you, Your Honor. With regard to Mr. Hawkins, I've been dealing with him for some time, assisting with these legal matters. He has been keen and set on taking advantage of the specialty court, because I believe that specialty courts are designed for individuals like Mr. Hawkins that are dealing with issues, and they need that support and structure from a team that can help them understand their issues and put different resources in the community. We did apply for Veteran Treatment Court on May 30th. He was denied that court, albeit being a veteran and having served this country honorably, receiving an honorable discharge, because there is not a sufficient nexus between his issues and the service, according to the program, Judge. So after that denial, that program we went ahead and had him considered for lifetime recovery. We did reach out and have him screened, and we do have documentation here that he does meet criteria and can go there if allowed by the court. We also reached out to felony drug court in advance to see if he would meet criteria for that program as well. I do have documentation here that he does meet criteria. However, he was denied at that time because it is obviously, as the court is well aware, post adjudication program, and we're not at that stage as of this time. So Judge, he's been dealing with some issues. He did graduate from University of Houston with an accounting degree in 2010. However, some of the issues he's dealing with, namely surrounding substance use, he uses methamphetamine, things of that nature, had led him to be homeless and has some interaction with law enforcement. The nature surrounding these offenses are not of an egregious type. He was arrested and fled out and made contact with the officer's shin, I believe. The other offense that he was charged with, Judge, he was actually at Cross Point, excuse me, and he was going to be emergency detained from there and taken to a facility. However, he was routed to the jail upon them alleging have spit on the back of the officer's head. So there is some issues here. We don't believe that the issues are necessarily attributable to a criminal mindset, more so a cry for help, a need for treatment, Judge. So we're asking the court to consider the avenue of treatments with inpatient treatment facility. I referenced the PSI, and the PSI is recommending inpatient treatment. We're asking for that to be ordered, Judge, so he can be transferred from here to lifetime recovery, have him doing well.
But what is, this says in the report, he declined to have a mental health screening, stating he didn't want to sign for any of the department's dual diagnosis programs or residential programs because he doesn't like the idea of sitting in jail for 4 months just to go to treatment.
This is a completely different legal landscape than what we just watched. Specialty courts, veteran treatment court, felony drug court, exists specifically to divert people struggling with addiction or service-related trauma away from straight incarceration and into structured, supervised treatment. Hawkins tried for Veterans Court first and got denied because the program couldn't establish a direct link between his mental health issues and his military service. A technical but very real bar plenty of veterans hit even with an honorable discharge on paper. Now his attorney is threading a needle between two remaining options. Lifetime recovery, a residential facility Hawkins is willing to go to, and the county's own dual diagnosis program, which he's actually refusing because of how long the wait could be. And that's worth sitting with for a second. Here's a man asking for treatment, but pushing back on the specific version of treatment because he's terrified of sitting in a cell for months waiting on a bed. Is that a legitimate practical concern, or is that Hawkins still trying to control the terms of his own recovery? That tension is exactly what the judge is about to weigh.
Yes, Judge, and if I might clarify that, I believe he's maybe had heard word around the jail that maybe the DDRF times are long. They could result in months-long waits to get him into facility. And I think that he's been in custody for a number of months now. He's wanting to get a hold on his treatment and recovery, and believes that lifetime recovery would probably be less of a wait time to get him into that treatment, Judge. So I did explain that in the PSI with him, and he stated that was his concern about the mental health facility being a much longer wait, and him waiting in custody until a bed opens up. Where, in contrast to that, the Bexar County is notifying me that they do have space for him at lifetime recovery, and they can readily transfer him there to get him on the road to his recovery and to turn his life around. And my suggestion, and I think the court hopefully is on the same mindset, that if he does that, it's going to put him in a better place to work the felony drug court program, which he meets criteria for, and give him that access to that specialty court, which we were vying for and trying to get with the veterans treatment court, but he did not meet criteria for that, Judge. For these reasons, we're asking respectfully for the court to consider that. I do have the treatment documentations of them evaluating him, Judge, as well, for the court to consider. Just to verify. It's my understanding, confirmed with the state of Texas representatives, that they're silent as to this request because they see the need for him to get some treatment and some help. And he's been patiently waiting for us to try to get it together to hopefully create these avenues for him. And I think we have some options and availability here, Judge, to get him some treatment over just incarceration.
All right. I see that he is a veteran and was honorably discharged.
Yes, Judge.
And it appears from reviewing the history and reviewing the instant case that there is an issue with drug use. There's an issue with mental health. Now, whether that mental health occurred due to his military service or not, the court doesn't have that information. So I'm going to give you a choice. Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. So I can sentence you to 4 years in prison, or what's going to end up happening is I'm going to refer you back to felony drug court because I know they have a dual diagnosis program.
That line right there. You can't choose how your recovery is going to look, might be the single sharpest moment in this entire hearing. The judge is calling out exactly what we just flagged. Hawkins wants treatment, but he wants it on his own terms, and she's not having it. Her ultimatum is blunt: 4 years straight to prison, or a shot at felony drug court's dual diagnosis program, with the explicit warning that if that program doesn't accept him, he's headed to state jail anyway. There's no guaranteed soft landing here. This is the reality of specialty courts that a lot of people don't realize. You don't get to negotiate the treatment plan once you're in one. Comply fully, or the alternative is incarceration. It's simultaneously more compassionate than a straight prison sentence and less flexible than people expect. Do you think the judge made the right call forcing that choice, or should Hawkins have had more say in his own treatment path, given his honorable service? Let us know in the comments, because what happens next determines the rest of his sentence.
If they don't accept you, you're going to safety. So those are your choices.
Is, Your Honor, just for clarification, the felony drug court dual diagnosis, is that within the felony drug court
Yes.
program? Would it still be an avenue for him to get treatment at lifetime recovery? If
He's going to felony, if felony drug courts accepts him, then drug court will set its conditions. If felony drug court does not accept him, he's going to safety.
Okay, yes, understood, Judge. If we could be considered for the felony drug court and then whatever recommendations they may have, as long as they're reasonable, Judge, we'll definitely, he'll be on board with that.
No, I mean, felony drug court,
Yeah.
it doesn't matter if people think their recommendations are reasonable or not. It's, if he goes to felony drug court, then felony drug court is going to set his conditions. If he goes to felony drug court and he says, I don't want this, then what's going to end up happening, a motion to revoke is going to be filed.
Yes, Judge, I understand. And ultimately, we're looking for an avenue for him to get treatment through a specialty court. So that's with the recommendation of felony drug court piece. He wanted me to voice that he would like to be considered for that and take part of that program.
All right, the court is going to sentence you to 8 years deferred adjudication. Take in consideration 2023 CR 7315, 2024 CR 5389, 72900. He's to remain in custody for the following evaluations: a referral to felony drug court. If not accepted, then safety, followed by aftercare, field visits, 1 time per month until further notice. And I'm sorry, instead of the anger management probation, it's going to be this a hostility management aggression control program. There's to be no contact with K Talley, Talley. And probation with regards to the MIC, maybe the best place for that if he's not accepted in to felony drug court. Once he's released from safety, if we do the mental health treatment through the VA. Probation, also, we'll do 200 hours of community service restitution. Probation, is there anything else he needs? I'm sorry?
No, sir.
Is there anything else you need from the court to be successful?
No, Your Honor. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do
Understood.
you understand?
Yes, ma'am.
And the court did not see any restitution amount for the officer. So state if there is going to be restitution to the officer, you will need to provide that within 30 days.
Yes, Your Honor.
All right, is there anything else?
Nothing further, Judge. Thank you for.
Based on everything the court record shows us up to this moment, here's where both cases actually landed. Let's recap fast. Nathan Montoya, deferred adjudication denied, found guilty, sentenced to 7 years, no right to appeal, permanently barred from owning weapons as a convicted felon, with the judge herself acknowledging his own history of abuse, even as she held him accountable. George Hawkins, a much more layered outcome, 8 years of deferred adjudication rather than straight prison time, contingent entirely on whether felony drug court accepts him into their dual diagnosis program. If they do, he gets a real shot at treatment. If they don't, he goes straight to state jail. 2 men, 2 different paths through the same system. One closed off by an unconvincing answer to a simple question. One kept open by a judge willing to bet on treatment working. That's the real tension at the heart of sentencing court. How much do circumstances matter, and how much do they not? So what did we actually learn from tonight's docket? These 2 cases sit on opposite ends of the same spectrum. In the Montoya case, the court made clear that acceptance of responsibility has to come with real, demonstrated introspection, not just a plea and a clean record. Without that, deferred adjudication was off the table, and a 7-year sentence followed. In the Hawkins case, the court leaned toward treatment over pure punishment, but made it just as clear that treatment isn't a menu you get to pick from. Comply with the program you're given, or face the prison time waiting behind it. Both rulings underline something worth remembering. Judges in these hearings are constantly balancing accountability, public safety, and the defendant's own history and trauma, often with only a PSI report and a few minutes of testimony to go on. It's messier and more human than most courtroom TV ever shows you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.